We're doing conspiracy. Talk a little bit about conspiracy. I'll say this. Let's see. Who's had me more than 2 times? Somebody had me 3 times? 3 times? You had me 3 times? I wasn't going to do this. I wasn't going to volunteer to do this. Do you know why I wasn't going to volunteer to do this presentation? Huh? Because I asked them if there's going to be courtroom journals. And they said, no, you can't do courtroom journals. And I was like, well, if I can't do courtroom journals, I just can't teach a class, all right? That's a requirement for me. All right, but nonetheless, I'm still here. We're going to talk about inchoate crimes today. And specifically, we're going to talk about conspiracy, all right? So first thing, let's get some definitions, or at least one definition. What is inchoate crime, all right? Some people call it incomplete crime. I don't call it that. Excuse me. I call it anticipatory crime because the crime is actually completed. And that's one concept you want to make sure you keep clear, that the conspiracy, whether or not the conspiracy is complete. But that's what I call these crimes, anticipatory crimes, not necessarily incomplete crimes. But these are a category of crimes: conspiracy, solicitation, and attempt. Today I'm going to focus on conspiracy. I'll talk a little bit about solicitation and attempt, though. And if you have any questions, just feel free to ask. All right. Conspiracy is a what? A specific intent crime. So I don't want to introduce terms that maybe folks aren't familiar with or haven't gone over. So let's just take a step back, go back a couple years, and think about our criminal law 1 course. All right. Specific intent, there's 2 mental states, all right, at common law. There's 4 mental states for the Model Penal Code, 2 for common law. Those mental states are general intent and specific intent, all right? Those 2 mental states, general intent and specific intent. Why do you need to know? Why should you care, all right? Those are the definitions up there. Some people understand these definitions, others don't, all right? So you may learn them better by just looking at the types of crimes that are listed as general intent and specific intent, all right? General intent doesn't require any additional mens rea, all right? Just awareness of all the factors constituting the crime, okay? Specific intent requires a sort of heightened mens rea, all right? You have to intend to engage in certain conduct, all right? So burglary, all right? The unlawful entry in the dwelling house of another at night with the intent to, all right, to commit a crime, a felony therein, all right? So that would be an example of specific intent. There's 3 specific types of categories in specific intent crimes, all right? The other type of specific intent crime is conduct will have some future impact, all right? This crime is hindering prosecution, all right? In hindering prosecution, you have to know that your act will hinder the prosecution of somebody else, all right? Another example of a specific intent crime would be knowledge that one or more elements of the actus reus exist, all right? So receiving stolen property, you have to know the property is stolen, all right? So those are 3 examples you have of what is a specific intent crime. You have to know the difference between specific intent crime and general intent crime because certain defenses will arise with specific intent crimes that are not available for general intent crimes. Right? That's really the big one. Right? There's specific defenses that are available for specific intent crimes. And then, where's the drum roll? Scarf baffle. Well, what does that mean? All right? If you like acronyms, here's one for you. Okay, those are all specific intent crimes. And maybe that may help you better see what constitutes a specific intent crime. All right. Today for us, we're going to focus on conspiracy. And these slides I have here, I will give them to Professor Worthman or Professor Cochran, and she'll post them if you want these. All right. Trying to go, paperless, so I avoid printing these out. All right. So we're back to our conspiracy, what we're going to talk about today. So when you have a crime, and I don't know, you might want to fill this out for people. I've heard this go either way. Whether or not, and as an essay question, you want to spill this out, give this to the exam reader. It may be just good to have this information to put it, you may want to talk to Worthman and Cochran to see if this is a good strategy. I defer to them on any bar-related question because they know far more than me about the bar stuff. They live it, all right? But all crimes have basic 4 requirements, all right? You have to have the actus reus, you have to have the mens rea, you have to have concurrence, you have to have causation. You need those 4 things for almost every crime. Now, people will debate with you whether or not there's a mens rea requirement for statutory rape, right? Because that's a strict liability crime, all right? People will debate that issue with you. But generally speaking, you need these 4 requirements for a crime, all right? So we're gonna look at them, well, at least the first 2, because we're not gonna look at concurrence and causation with respect to conspiracy, because that's not an issue. You're gonna see those type of issues pop out in homicide, all right? When the causation problem comes, usually it's gonna be homicide. Who caused that person's death, all right? Whether the direct cause or proximate cause. So for us, we're mainly gonna be focused on the actus reus and the mens rea. Okay, so for conspiracy, you have to have an agreement between 2 or more parties, all right? So, what I think is helpful too to try to jump in the mind of the test taker, they're not gonna say, you signed a contract on a dotted line to agree to something, all right? You're gonna have to infer sometimes whether or not there is an agreement, all right? Express or implied, okay? Next, you have these 2 mens rea requirements. Intent to enter into an agreement with the purpose to achieve the objective of the agreement, all right? That's the mens rea element for conspiracy. All right, one thing about conspiracy, first of all, it's a great essay topic because you can do it in layers, all right? So if you're writing an exam for somebody, you always want to be able to do it in layers, all right? Makes it easier to grade, all right? It's easier to test people and their ability to spot issues. And this is a good one. Conspiracy is a good one to use. In addition, with conspiracy is good is because there's nuances to conspiracy. And it differentiates between the model penal code and the common law, all right? So you can trip people up that way, okay? If they don't know the differences between the model penal code and the common law, all right, they'll make mistakes, all right? So you gotta memorize these differences, all right? Model penal code, you need an overt act, all right? You have to be able to distinguish an overt act between a substantial step. All right? Overt act is gonna be less than a substantial step. Substantial step is a concept you see in attempt, all right? Attempt, you need specific intent and a substantial step, all right? Specific intent to commit a crime and a substantial step. Now, with conspiracy, model penal code requires an overt act. Keep that in your mind, keep that in the back of your mind now, because when you read a fact pattern, when you see a problem, don't run to assume that all the elements have been filled. All right, especially if you haven't seen an overt act, all right? But the common law, as you see, does not require an overt act, okay? An overt act can be almost anything, all right, to set the conspiracy in motion. A second meeting, all right, on the way to go someplace, go get an object. Doesn't have to be illegal, all right? Anything to get the conspiracy going, all right? So look at this idea. Common law requires 2 guilty minds. What does that mean? All right? That means that common law, you cannot conspire with an undercover cop. All right? Common law, you cannot conspire with an undercover cop. As you probably know just by watching television, almost every jurisdiction is changed from the common law, all right? Because cops are always undercover, all right? They're all on backpage.com. All right, soliciting people, okay? They can do that in the model penal code. Common law, you couldn't, all right? Got to have 2 guilty minds. Now, they'll call that bilateral agreement or plurality agreement, all right? They'll use those terms, all right? MPC doesn't require that, so they use the term unilateral agreement. Again, when they test you on this, they're not going to come out and say, this person didn't have a guilty mind, that person did have a guilty mind. They're not gonna make it easy for you like that. They're gonna make it hard, all right? So if they wanna make it really hard, they will try 2 people together, all right? And then acquit one of them, all right? And then you could say, well, you didn't have 2 guilty minds, he was acquitted. All right, they wanna make a real hard problem, okay? So think about that whether or not both those parties, all right, are defendants or somebody's undercover. All right, this is probably the biggest thing, I think, with conspiracy. Probably the biggest thing. All right. Your liability for co-conspirators, well, I say this and withdrawal are two biggest things, but your liability for co-conspirators' actions, all right? They're going to give you a fact pattern. It's going to say such and such had an agreement, and then someone's going to have a falling out, or someone's going to do something that you didn't think they were going to do, all right? And someone's going to get hurt. There's going to be a victim. There's going to be an injury. Something's going to death. Something's going to happen. They're going to say, are you going to be liable for that? For what your co-conspirator did? And they'll say, well, I didn't know they were going to do that. I told them to do this. Are there going to be liability? Okay? So you will be liable for the co-conspirator's actions in furtherance of the conspiracy and for foreseeable. All right? Committed in furtherance of the conspiracy and foreseeable. Those are the requirements. Be liable for co-conspirators' actions. It says this third prong here doesn't matter if the other conspirator is unaware, uninvolved. All right? That's what they call Pinkerton liability. I don't know if y'all read the Pinkerton case? All right, these brothers were doing some shady dealings, all right? One brother was actually in jail, all right? The other brother did the crime. So the brother in jail says, you can't get me, I'm already in jail. Government says, yes, we can, all right? Because you knew the crime you agreed to do, that what you conspired to, it was reasonably foreseeable, all right, that this second crime was gonna happen. So we're gonna hold you accountable for your brother's actions. Okay? That's called Pinkerton liability. So it didn't matter the fact the guy was sitting in jail. They held him accountable. Let's look at merger. Conspiracy does not merge. All right? Conspiracy does not merge. All right? You can charge them with conspiracy and you can charge them with the underlying crime. All right? The other inchoate crimes merge. All right? What is solicitation? Go down the streets of Dayton, go on, what is it, 3rd Street? Streets of Dayton around Friday. I don't know, it doesn't even happen at night anymore. It happens all day. I even say that. It happens all day. When you encourage, entice, request someone to commit a crime, all right? Do you want to go to the UDF with me to commit a bank robbery? I'm soliciting her to commit a crime, all right? When she says yes, what do we have then? A conspiracy, because now we have an agreement, all right? So you're not going to charge, all right, solicitation and conspiracy. So what are they going to do? How is this going to be first? How are they going to trick you? They're going to give you a fact pattern, and they're going to say, this is kind of the hypothetical I just gave you right now about me and her going to the UDF. They're going to say, list all the crimes that she can be charged with. And they're going to say, they're going to charge me with solicitation because I asked. Then they're going to say conspiracy because we agreed. And then we're going to say robbery because we went to the UDF and pulled off a robbery. They're going to say solicitation, conspiracy, robbery. Wrong answer. All right? Because you cannot charge solicitation and conspiracy at the same time. All right? Because that solicitation merged into that conspiracy. All right? So that's how they're going to test that. So you have to be very careful in looking at which crimes merge. All right? That's like robbery. We committed a robbery. We stole some money. We assaulted somebody. You cannot charge somebody with larceny, assault, and robbery. You can charge them with larceny and assault. You can charge them with robbery, but you cannot charge them with larceny, assault, and robbery. All right? So here, conspiracy does not merge. All right? Solicitation will become conspiracy if the person agrees. You can't charge them with solicitation, conspiracy, and the underlying. You can't charge them with conspiracy and solicitation. All right? Attempt merges with the underlying crime. Okay, you're not going to not attempted robbery and robbery. All right, you're not going to charge that. Okay, Wharton's rule. All right. So, when you see dueling, when you see bigamy, when you see adultery, when you see a crime like that, sometimes gambling, sometimes selling of drugs, but generally not. Generally, bigamy, dueling, or adultery. If you see a crime like that. A crime that requires two people. You cannot really duel with yourself. No, I don't think. Maybe, no, you can't. You need another person. You need another person, all right? Can't marry yourself. You got to marry somebody else, all right? Adultery takes another person, okay? All right. Yeah, because I don't think you and your avatar is going to count, all right? You need another live human being, okay? So when you see those kind of crimes, think of Wharton's rule, all right? Wharton's rule says you can't charge conspiracy and the underlying crime. Remember, generally speaking, you can charge conspiracy and the underlying crime. You can't charge conspiracy and the underlying crime where it's a crime that you have to have these people to do, at least two people to do. At least two people to do. Dueling, you have to have two people. Bigamy, you have to have two people. Adultery, you have to have two people. Sometimes it also will include incest in this as well. So with those type of crimes, if they're talking about the words, you can't charge them for both. All right, you pick one or the other. You can't charge them for both. There's an exception to that general rule where you can charge both conspiracy and the underlying crime. So there's the rule. No Wharton's rule. Now the exception to Wharton's rule. If you have more people there than necessary. All right, so dueling, you have 3 people in a duel. Well, we don't need 3 people to duel, we only need 2. All right, so if you have more than people necessary, then Wharton's rule doesn't kick in. All right, Wharton's rule then doesn't kick in. Also, if you have questions, feel free. Feel free if you have questions. All right, this is a big one right here, withdrawal. Withdrawal. All right. The key, I think, to withdrawal is know when conspiracy is complete, when you've met the elements of conspiracy. My example here, I asked her to go to rob the UDF with me. She said yes. Conspiracy at common law. Model penal code, we need what? An overt act? Let's meet again. Let's get some weapons. Let's get something else, okay? Complete. Conspiracy is complete. She gets cold feet. I don't want to go to UDF. I got a future ahead of me. I'm not doing that. She gets cold feet. She wants to withdraw from our conspiracy. Can she withdraw from our conspiracy? All right. At common law, she can't. It's done. We got a conspiracy. You're not going to. So when you see on a fact pattern, them saying, oh, I withdraw, I don't want to be part of this anymore, it's too late. The conspiracy is done. All right. Conspiracy is done. Now, at the model penal code, you can withdraw from a conspiracy. You have to be voluntary, meaning the police can't catch you. You can't do that. And you must work to thwart the conspiracy. All right? So you can withdraw the model penal code. Again, I advise you, make a little list. I have a slide with the list on it. But list, model penal code, common law, what are the differences? Make sure you know the differences. All right? So they can't, because they're going to want to test you. They probably will test you on that. All right? So you can't withdraw from the conspiracy. What can you withdraw from? You can withdraw from subsequent crimes. All right? So when she withdraws from my little conspiracy, I go to the UDF, I hold the place up, someone gets shot, that's robbery, that's felony murder. She's not going to be part of that. All right? She'll get stuck with the conspiracy, but she's not going to be part of that. As long as she gave notice to everybody that she's withdrawn from the conspiracy. See, and then maybe you can start seeing how I can layer a problem like this. I can start doing this problem in layers here and seeing where the test takers pick up on these issues, because I'm going to write them out. All right? Was there an agreement? Was there a substantial step? Then did someone withdraw? Can you withdraw? What did you withdraw from? All right? So those are different layers you can write in a fact pattern to test people on different areas of conspiracy. All right, you don't see impossibility, and I don't think I've ever seen a problem with impossibility, a conspiracy problem with impossibility. I raise it because you see it with attempt, all right? And it's kind of confusing to people. So I'm gonna talk about it in respect to attempt. Factual impossibility is not a defense, all right? Legal impossibility is a defense and attempt. It may be a defense with respect to conspiracy. All right. So what's the difference between a factual impossibility and a legal impossibility? This is hard because it varies sometimes by state, all right? Because they're not sure about it. All right. A factual impossibility, all right? Pickpocket finds an empty pocket. It's factually impossible to pick a pocket. There's no wallet in there. I'm broke. It's impossible to rob me factually, you know, to rob me because I have no money, all right? That's not a defense. The fact that you picked someone's pocket and found nothing there, that's not a defense. The fact that you tried to rob me, Professor Hoffmeister, and he's broke, that's not a defense. That's a factual impossibility, all right? A legal impossibility is a defense, all right? Legal impossibility is when you touch someone's elbow and you think it's sexual assault. All right? You think it's illegal to have this medication, so you do a bogus a forgery for cement when that's not illegal. All right? A legal impossibility. All right? A legal impossibility is a defense. All right? A factual impossibility. This is all common law. All right? The model penal code has changed that, but this is common law. Factual impossibility is not a defense. Legal impossibility is a defense. The problem you have, and this is the reason they moved away from this in the common law, is because they got to a point they couldn't distinguish the difference. I gave you the two broad spectrums. Factual impossibility, pickpocket finds an empty pocket. The pure factual. Legal impossibility, you think touching someone's elbow is a sexual assault. All right, that's not by law, that's not sexual assault, okay? But what happens when someone shoots a dead person? All right, when someone shoots a dead person, all right, is that factual impossibility? Is that legal impossibility? All right, is that factual impossibility, legal impossibility? All right, is that attempted murder or not? Oh, it's attempted murder. All right, you wanted to kill the person, you shot him, the person's already dead. All right, is that factual impossibility? Is that legal impossibility as a defense? Some states say that's a factual impossibility. Some states say that's a legal impossibility. All right, that's a hybrid. All right, all right. So that makes it kind of challenging to raise that. Okay, but I want to point that out there just so you see the difference. Model penal code takes somewhat of a different approach. All right, impossibility, I've not seen it on conspiracy, only on with attempt. Okay. This chart here, you might want to keep a chart like that just to help you understand the difference between the two. Everybody ready to do some problems? Minute and 48 seconds. Got you on the clock. If everybody got this done, I'm going to turn to the next slide. It's going to be problem time. Is a minute and 48 to do 200 problems? I mean, minute and 48 for 200? 200 questions on the MBE? 200 questions? For each one? Okay. course, it's going to be tough because all the information is not on one slide, so I guess we won't hold you to the clock. Okay. You ready? Which one is it? Okay, all right. Don't get overconfident. They get progressively harder, all right? So why is it A? Yes, because conspiracy does not merge with the completed offense, so convictions of both the completed offense and conspiracy to commit the offense would be allowed. All right. Not one of those wart rule type of issues. Okay, which one is it? All right, on a roll, on a roll. With the fact pattern again? Yeah, all right, they're confident. What's the answer? All right. This one's a hard one. Ready? I'll say this involves more than conspiracy too. Which one? I don't hear any voices this time. Which? A? How are you, okay. How are we getting the friend? Yeah. How do we get the store owner of Doormark? Okay. You know, generally, also too, I have this theory that always punish people on criminal law on criminal law questions. Usually, it's safer to always punish as opposed to exculpate people. Just my own theory of how these things work. Yeah, you get him on accomplice liability. That's how you get him on that. Yeah, yeah. Want to see the fact pattern again? Okay, which one is it? Who says, that's kind of the key too, I think, too, for these things. It comes down to two. You're guessing between two good answers, all right, generally speaking. Why would people say D? Because he didn't effectuate. Okay. Now, is that what you have to do for the conspiracy itself or subsequent crimes? For is that how yeah, no. Subsequent crimes, they have to give notice to all parties. Okay. Here you could say they didn't give notice to all parties. I thought about this in my mind. I was like, because there's another guy there, and they didn't do that. I didn't specifically state that. But on the hook for conspiracy. All right. On the hook for conspiracy, not on the hook for subsequent crimes, unless you found that when this person withdrew, he didn't tell, I guess, Mike, because he didn't tell all parties. I thought that too. I was like, because I wrote this question, I was like, well, are they going to assume, are they going to know that they're all in the car together and that he heard them?
So if he would have worked at Ford, he would have been
Yeah. On the model penal code. Yeah. Okay. Bar exam outline. Okay. So here is sort of the outline of the stuff that you need for the bar exam. All right. So if you haven't covered this stuff in the basic criminal law course, you might want to start reviewing those topics sooner rather than later. So we had the basic premeditation, murder 1, provocation, you're looking there, voluntary manslaughter, unintended killings, reckless and negligent killings, felony murder. Felony murder is always on, very popular. Misdemeanor manslaughter, all right, or involuntary manslaughter. Property crimes, theft, burglary, robbery. They like the property crimes, theft, because it's easy to trip people up on theft, on those crimes. It's because, you know, the thing with theft, those property crimes like the larceny, embezzlement, and false pretenses, okay, you have to know if the person is getting just possession or is he getting title. You know, is it larceny by trick, or is it false pretenses? All right, everything's the same for the most part. One you're getting title, one you're just getting possession. All right, understand with these theft offenses, when did they formulate in their mind that they're going to steal the goods? Okay, you gotta keep that in the back of your mind here. It's like, did they know before they were going to go there and steal, or did they steal after they already had possession? All right, because that kind of distinguishes embezzlement and larceny. All right, burglary, you got to know those elements of burglary. You got to know robbery. You know, you have to put the person in fear. What happens when you go to the UDF? I mean, what's the difference between you go to the UDF and you put your hand out like this and say, "Give me the money"? All right, you're not going to put anybody in fear like this. You're going to put them in fear when you do this, because they don't know what's behind that. All right, understand the mental state requirements to conduct robbery. All right. Other crimes, assault, battery. You see these sometimes, not the biggest ones there. You see them sometimes. Requirements for arson. Understand the mental state for arson is the same as murder. They're the only two crimes that use malice. All right, that use malice though. So once they do malice, that means if it's a malice crime, intoxication will not be a defense. All right, so you can get drunk as you want. It's not going to impact murder or arson. Now, distinguish that from first degree and second degree murder, because if it's a specific intent crime, alcohol intoxication can make a difference. All right, take away a mind state. Inchoate crimes, we talked about that. Parties to a crime, accomplice liability, you know, accessory before the fact, accessory after the fact. You want to know those. Not heavily tested, but you still want to know those. General principles, state of mind. Okay, required mental states. You know, there's 4 mental states. There's 2 in the common law. We talk general intent, specific intent. 4 model penal code. Knowingly, purposefully, negligently, recklessly, strict liability. Mistake of law, mistake of fact. Oh, so that's one that you want to look at. So, I can say that briefly. So another reason why you need to know the difference between specific intent crimes and general intent crimes, because whether or not a mistake of fact can be reasonable or unreasonable. All right, specific intent crimes, they can be unreasonable. All right, I'm talking mistake of fact. All right, mistake of law, generally not a defense, unless, you know, there's those 2 exceptions. You relied on someone telling you something who was in a position to tell you, like, for example, if your probation officer told you, oh, it's safe to own this firearm, you can do that. Okay, that would be a mistake of law defense. Okay, or if there's some, you're charged with one crime, say example, you are charged with a sex-related crime, you have to register on the sex offender, and a reasonable person would not know that they had to register and you didn't have notice, that might be a defense to mistake of law. Generally speaking, there are very few defenses to mistake of law. Those are the 2. Mental disorder. You want to know the rule from McNaughton. McNaughton is the most popular common mental disorder that you see on the bar exam and in this practice. So you want to know that. Intoxication, causation, justification, excuse, jurisdiction. All right. Constitutional stuff. Search and seizure, you know, is going to be on there. Miranda, things like that. 6th Amendment right to counsel. Okay. Double jeopardy. Yeah. Okay. It says you half criminal law, half in criminal procedure. All right, so just talk about the bar. I have like 3 or 4 minutes left. Just talk about the bar exam. Look, so everybody's going to come here and give you their spiel on the bar exam. All right. So I'm admitted in 4 jurisdictions. I've taken the bar exam twice, and I have some familiarity with the exam. Look, I first took the bar exam when I was a law student. Certain states allow you to take the bar exam early. I took the the bar exam and passed it when I was a third-year law student. I did that not because I'm inherently smart, all right? I did it because I had discipline. And I'm telling you what the bar exam is about. It is about discipline, really. If you discipline yourself, you will succeed, all right? It is rote memorization. In my opinion, the bar exam is rote memorization. It's not the LSAT. They're not trying to configure how you analyze similar things or how your mind works. They want to know if you know the black letter law. All right? They want to know if you know the black letter law. So already you are a step ahead by just being here, getting up to speed right now on this exam. But it requires you to take the time. You have to focus and carve out the time for these exams. Someone told me when I was studying, I don't know if it's true still, but it was like, if you do 2,000 questions, you have a 90% chance to pass the bar exam. When I heard that, I was like jumping for joy. I love statistics like that. I love when someone tells me that if I do this, my rate of success is very high, and that's what it was. And you have to do these questions. I'll let you in on a little secret. There's only so many ways I can test felony murder, all right? Because it's the same holding, it's the same rule of law. So they run out of ways to test you, all right? That's why some people don't like to release their exams, because they can't think of new ways to test you, all right? So what you want to do is take as many multiple choice questions as possible. When I sat for the bar exam in California, I knew at least 25% of the questions. I had seen them before. Now, they could change the names. I can see through that. I know what they're testing. I've seen these before, all right? So that was half the battle of doing all these questions because it was familiar to me, all right? So you have to discipline yourself. You have to do these questions. Remove distractions. I saw someone post on Facebook on this school saying that they're going to stop posting because bar exam is 2 weeks away. No, you remove those distractions from day one. All right, they shouldn't be doing that. And think I didn't have stuff like social media when I was studying for the bar exam. But remove those from day one. I mean, if you're not raising kids, there should be nothing else you're doing but studying for the bar exam. Honestly, everything else will be there when you come back. Everything, relationships, the football season comes around every year, whatever, it's going to come back around. You want to remove those distractions and focus. All right, focus. And never too early to start studying. Never. Like I said, when I did it as a law student, I started insane early to study for this February exam that I took. And you can do that. You have it in you. You just have to discipline yourself. Sit there, memorize and outline and practice, and it will come. And you'll come to a moment where you're just like one with the bar. Everything else is a distraction. And finally, use the resources that we have here. Call on Professor. Unfortunately, she's retiring, but call on her work her to the last day she's here. Work her. Go down to Professor Cochran, ask for help, ask how you can get her for the bar exam, and then also Professor Worthman, all right? Rely on them, okay? Rely on them. And if you have any criminal law questions, don't ask them anything about property, don't ask them anything about contracts. But if you have a criminal law or criminal procedure question, I will give you an answer, or I'll hunt it down and find the answer for you. But anyway, I'll respond to you if you have a question about the bar exam on that matter.